Hello everybody, I'm George from Ireland. This video is about judicial review. So first of all, what is judicial review? Well, the Criminal Justice and Court Act 2015 tells us, because it provides some explanatory notes. So here is the official definition. It is a process by which individuals, businesses and other affected parties can challenge the lawfulness of decisions, actions or inactions of the executive, including those of government ministers, local authorities and other public bodies, and those exercising government functions. Now, the Ministry of Justice then, in 2013, they published their judicial review proposals for further reform, and they had this to say about judicial review. It is a critical check on the power of the state, providing an effective mechanism for challenging decisions, acts or omissions of public bodies to ensure they are lawful. So public bodies are the government, any government ministries, next steps agencies, the police, the armed forces, local authorities, it could be borough council, county council, and so forth, city council, mayor, all these things are public authorities. So think of it as a way to apply a certain rule. You might remember Entick and Carrington, a case from 1765, which talks about legality, that just because the government does something, it doesn't automatically make it legal. That if the government's doing something, it must have some lawful basis for doing that, that statute or common law provides it with the power to do that thing. So we know that there's a rule of law, and therefore public bodies must act within their remit. They mustn't transgress legality. They mustn't do things which they're not specifically empowered to do. So they must act in consonance with natural justice. So judicial review enables the courts to ensure that public authorities are adhering to these standards, and ensures that some accountability in law for the acts of the executive, or indeed the inactions of the executive and other public bodies. So this is really the key task of administrative law. So this ensures that the rule of law is effective, that the government is kept within its limits and so forth. So what are the parameters of judicial review? So this is a sort of court action which entitles the court to scrutinise the lawfulness of a decision and rule whether it was lawful or unlawful, and then it provides some sort of remedy against the public body if the public body has done wrong, if it's exceeded its powers or in some other way breached the law. Now that is different from political accountability, and political accountability is something which is achieved through legislatures. So we mustn't confuse the legislative with the judicial function. So judicial review is vital in making sure that wrongful or illegal use of power, misuse of power I should say, can be stopped, and therefore ensures that there is a legal accountability for the executive or all types of government. So anyway, judicial review is often controversial because it allows people, ordinary citizens or various organisations, to check the unlawfulness of governmental decisions, both in the sense of verifying that it is lawful, but blocking it if it's unlawful. So these decisions which are rendered by ministers, by various departments of state, by your county council, city council, and all the rest of it, right down to parish council. So we must realise that whilst this is something which sparks spirited debate, it's not supposed to be used for political reasons, to bring things which are primarily politically motivated. And it is very tricky because the dividing line between politics and the judicial sphere is not clearly defined. There is a blur, the things which can be both judicial and political. So judicial review is not appeal. This is often a misunderstanding. So what's the difference between them? Well, the vital thing to realise is that the judicial review is much more restricted than appeal. So there was a judge with a very apposite surname for judge, Laws, and Justice Laws had this to say in R and Somerset County Council ex parte feuings in 1995. In most cases, the Judicial Review Court is not concerned with the merits of the decision under review, the court does not ask itself the question, is this decision right or wrong? Far less does the judge ask himself whether he himself would arrive at the decision in question. The task of the court and the judgment at which it arrives have nothing to do with the question, which view is the better one? Okay, so is this policy desirable? Is it likely to succeed? Is it cost effective? They're not asking that. So they're not asking whether it conforms with their political ideology, if they have one. Is it likely to win more votes? How will it play out in the press and the next election? No, these are questions which are not in the court's mind. So it's crucial that the courts don't intervene in a minister exercising his political judgment simply because the court dislikes that opinion or dislikes the minister who's made the decision, things like that. Now, courts only step in if there's something wrong with the procedure, if it's something unfair or unlawful has been done. So judicial review only functions within strict limitations, and the purpose of the court reviewing the decision is in order to superintend the minister's use of his discretionary powers. So you have to see that this discretion has been enacted lawfully. So this the court's function is supervisory, not an appellate function. So this is different from appealing a decision, because the appeal is often built into the legislation saying, and yes, you can appeal about this. But there is no unfettered right to judicial review. So the claimant, as the person moving the action, seeking judicial review, must seek the court's leave to apply for judicial review. Leave means permission in this case. So if there's an appellate jurisdiction, bodies can decide about whether the case is meritorious or unmeritorious. Whereas in judicial review, what the courts are really looking about is the legality of the decision and the process by which the decision was arrived at, not the core of the decision, not the really meat and potatoes of it. So judicial review is not about the court trying to think, has the public body made a wise decision, a desirable decision, anything like that? Is it politically astute? No, that's the wrong approach. So the court has to examine what the legal grounds for making the decision were. Was the decision maker, the individual, the body, lawfully entitled to make such a decision? Was it beyond their remit? Was it ultra vires, or what? Was there a procedure which should have been followed and hadn't been followed? Things like that. So the court is therefore considering whether the decision is lawful or not. They're not seeing whether it is a good or a bad decision as such. So Lord Bingham, in our Corner House research and the director of the Serious Fraud Office 2008, had the following to say in the House of Lords about judicial review. He said, "The issue in these proceedings is not whether the decision was right or wrong, nor whether the divisional court of the House agrees with it, but whether it was a decision which the director was lawfully entitled to make." Because what if the director had made a decision he was not lawfully entitled to make? Well, then that has to be reversed. Moreover, so when you're looking at judicial review, the court is not trying to interpose its decision in place of what the decision maker made. I know, sorry, awful phrasing. So the decision maker might be actually able to do the same thing in the end, but follow a different procedure. Sometimes there's meant to be some sort of public consultation. Let's say a third runway at Heathrow or something. I know it's a bit too close to the real world example. There's meant to be a public consultation, and then you can authorize another runway. Now, the government authorized another runway, but there was no public consultation. The court may say, no, you can't do that. Now, the government could then go back, do the public consultation, and then decide to have a third runway, which would be fine because they followed the right procedure. The outcome might be the same, but they have to go through the right steps to get there. Anyway, so in judicial review, what else shall I point out? Okay, so you have to see that the right procedure has been followed. There was a well-known case called Bryan and Secretary of State for the Home Department, 1991. And in this case, Lord Ackner said that the court was not going to impose its opinion about what ought to be done in the place of the decision makers' policy, because to do so, and this is what Lord Ackner said, would be a wrongful usurpation of the power by the judiciary. So the judiciary is not trying to step in and become political, become cabinet ministers or anything like that. So what's the classic view of judicial review? So perhaps the best précis of it was made by Lord Brightman in Chief Constable of North Wales Police and Evans, 1982. And this is what Lord Brightman said. Judicial review is concerned not with the decision, but with the decision-making process. Unless that restriction of the power of the courts is observed, the court will, in my view, under the guise of preventing the abuse of power, be itself guilty of usurping power. So what decisions are amenable to judicial review? Well, we could look at actions performed by public bodies. So these are things which are capable of having judicial review. So these can be examined in the courts. They're made by cabinet ministers, by junior ministers, various government departments, county councils, and all the rest of it, your health authority, your education authority, the police forces, governors of prisons, benefits agency, the highways agency, the passport office, and on and on. So bear in mind that public bodies, they are also accountable in terms of the law of contract, the law of tort and property, and so forth. So when judicial review is not being used, you might be able to initiate an action against a public body on the basis of tort or a contract or something like that. So the divide between public law and private law is complex. There's a case about it called O'Reilly and Mackman, 1983, which is very instructive. So this public body is made a certain decision, but what gives them the lawful authority to make said decision? Is it statute, as in a piece of legislation passed by a legislature? Could be Parliament, could be the Welsh Parliament, could be London Assembly or your county council's bylaw or what. So these are statutory powers. There was the famous GCHQ case in the mid-1980s, which established that prerogative powers are also subject to judicial review, which was something that many disputed at the time. So public bodies, they get their power from a statute, or indeed could be from a prerogative, and the prerogative can also be reviewed by the courts. So this is what Lord Wolfe had to say about it. Judicial review has developed to the point where it is possible to say that no power, whether statute or prerogative, is any longer inherently unreviewable, because many had maintained that the prerogative powers were immune from judicial review. So there are private bodies and there are public functions. So sometimes public functions are exercised by private bodies, i.e. non-state bodies. So the question is, are these subject to judicial review or not? So judicial review has developed, and it now can be applied to decisions made by non-governmental bodies if they are in effect exercising public law powers, performing a public law function. So something which is really effectively a governmental role. For instance, there was R and panel on takeovers and mergers ex parte Data Fin PLC 1987. The Master of the Rolls, as in the most senior judge in the civil division, he said that the public law element may take many different forms. Those were his words, may take many different forms. So in this particular case, this panel was ruling on mergers. Now, it wasn't a governmental body. It hadn't been set out by statute or indeed by prerogative powers. It was a voluntary body. It was self-regulating. It was sort of a watchdog of the financial sector. So Datafin PLC, they wanted a judicial review of the panel's actions. Now, the court said that judicial review was flexible and that it could adapt to the situation. Therefore, judicial review could be applied to this body because it was performing a public law role. So the panel was regarded as exercising a public function. So it was de facto a public body, even though no statute or prerogative actually said that it was. So the court was surprisingly creative, saying, "What are you actually doing, and not how do you come into being?" They will judge whether it's a public body on the basis of whether it performs a public law function, not the mechanism through which it was created. So the panel was meant to be acting in the public interest, and owing to the way it worked, there was an implied devolution of this function by the government to the panel, as though the government had actually said to the panel, "You take over this public law role." They hadn't actually said it, but the court said we can infer that that's what the government wishes. So what you look at is the sort of power that is being wielded, not where that power came from. So there are other bodies which are not thought to be governmental enough in type to be subject to judicial review. So this is what was said by Lord Justice Dyson in R. Beer Trading as Hammer Trout Farm and Hampshire Farmers Market Limited, 2004. He said you have to give careful consideration of the nature of the power and the function that has been exercised to see whether the decision has a sufficient public element, flavour of character to bring it within the purview of public law. So it might not be in the purview of public law. So there are things which are just a private relationship or something which is contractual, and these are not within the remit of judicial review. Now, a really good example of this is Aga Khan R and Disciplinary Committee of the Jockey Club ex parte Aga Khan, 1993. Aga Khan is leader of the Ismaili Muslims, but he's very involved in horse racing. In this case, the Jockey Club has a regulatory role with regard to the GGs in the United Kingdom, to horse racing. And so people who are members of that, they own race horses, and they're not usually the jockeys themselves. And so there's a contract aspect to this. So the Court of Appeal said that because even though the Jockey Club is crucial in regulating horse racing, the sports governing body did not, in fact, wield governmental powers, and therefore it was not a public body, and judicial review couldn't apply there. Right? If something is completely a private body, private company, or a private individual, no, there's no judicial review can be applicable to them. So let's see what procedure is required. So I must first of all see that there's justiciability, that this is an appropriate matter to bring before a court, and you have to ask the court's permission. And judicial review is a remedy that is discretionary. There are time restrictions. You've got to bring your action for judicial review promptly, and judicial review is not available if another possible remedy exists, and you need to have locus standi, as it has to be sort of relevant to you, a place to stand. So what is the justiciability aspect of this? Well, it must be about a public law issue, which on the face of it is justiciable. So non-justiciable means something, decisions that courts can't intervene on. So the powers would have a statutory basis or a prerogative basis, okay, but they might still be non-justiciable. For example, foreign policy is not justiciable, national security, the expertise of certain people is not, the budget, that's not justiciable. So some matters of public policy, like how high benefits are going to be, what taxes are going to be, no. Completely political decisions like sacking people from the cabinet, no. The judgment of professors or other professionals, no. The court's not going to be ruling on all these things. So these are thought to be more appropriately within the realm of the executive. So that's part of the separation of powers. So justiciability is something that the court decides on, is this justiciable or not? And Miller number 2 case shows that even people in the Supreme Court can disagree on what's justiciable. So in the High Court, there's a panel which includes the Lord Chief Justice, the Master of the Rolls, and the Presidents of the Queen's Bench Division. So in that Miller case, the judicial review action was trying to get a declaration that the Prime Minister's advice to prorogue Parliament for 5 weeks justiciable. Remember, it was R. Miller and Prime Minister 2019. So some matters can leapfrog us and can skip a court and go right to the Supreme Court, because if it's considered important enough. This is Miller number 2. And remember, the court famously found that the government's reason for proroguing Parliament was bogus, and therefore the Queen's signature proroguing Parliament didn't count, and Parliament came back. That was September 2019. So prorogation is when you close Parliament temporarily. It happens twice a year anyway, but they just wanted a third one out of the usual cycle. In the late 40s, the Labour government prorogued Parliament for a while to stop the House of Lords blocking something. You go back to the early 19th century, Parliament was once prorogued for 6 months. So prorogations are nothing new, or even John Major in 97 prorogued Parliament to prevent a highly embarrassing report coming out right before the election. So let's look at the need to get permission. So part of the procedure for judicial review is as per the Civil Procedure Rules 1998 and the Senior Courts Act 1981. So you don't automatically have the right to judicial review, but a claimant may ask the court's leave to get it. So there are 2 steps to this process. First of all, the court decides whether or not the claim is going to go ahead. That's the permission stage. And second of all, you'll have the proper hearing for the claim. It might be thrown out, no, we don't give you permission, but if we do, then you actually get a hearing. So if you do get a hearing, then it'll go ahead. So Sharma and Brown Antoine 2006, in this case, the Privy Council said that one part of this process, the court had to see that there's a realistic prospect of success. If it's a sort of a vexatious case, they're going to throw it out. That's frivolous, it's unserious, it's not worth our time. There's a very low chance that they'll win. Now, if you get permission, that certainly doesn't guarantee you're going to win, but it's worth hearing, it's worth considering, it's not ridiculous. So the Criminal Justice and Courts Act 2015 said there was a materiality threshold. So they can refuse his permission, and this is a quotation, if it appears to the court to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred, as in the thing you're seeking judicial review of made almost no difference. There are time limitations, and you must not tarry. Okay, a bit like the equitable principle, you must not sleep on your rights. So judicial review said that you must bring it promptly within 3 months of the reason for this having first arisen. So the reason, the time limit can be even shorter, 6 weeks in case of planning, because the people want to get on and start building things, not constantly delaying it, and not trying to reduce the number of challenges and reduce the wastage of money. So the court can prolong the time period if they think there's an extraordinarily good reason for that to happen. There was a case about this. It went out into 2 years in one case. R. and Secretary of State for Foreign Affairs, ex parte World Development Movement Limited in 1995. Now, under the Senior Courts Act, the court can consider whether there's been undue delay in applying for judicial review. It can refuse to grant permission because you're just too slow. And this is what the Senior Courts Act said, why they can refuse permission on the grounds of delay. If it considers that granting the relief sought would likely cause substantial hardship or to substantially prejudice the rights of a person and would be detrimental to good administration. So you have to run out of other possible ways to resolve this. So judicial review, as they say, is a remedy of last resort. There's no other way to rectify the situation. So that's why I have to go to judicial review. If you could appeal to tribunal or something like that, you must do that. You can't go to judicial review first. We don't want judicial review all the time. And the courts, they are loath to intervene in something which skirts the political sphere. It was Glencore Energy UK Limited and Revenue and Customs Commissioners 2017. And in this case, the High Court, who did not grant permission to apply for judicial review, it was about imposing diverted profits tax, and that was because there was statutory review and the appeals process hadn't been used, and they provided another possible way to resolve the situation. So you only have judicial review if there's no other way to deal with it. Now, then you've got to have locus standi, as in standing. It has to be relevant to you. We can't just have anybody who's really got no interest in the case sticking his oar in, and we'd have judicial review all the time. So locus standi say that you have the right to a hearing on this case. So when you're seeking leave for judicial review, the court will only give it, and this is according to the Senior Courts Act, will not grant it, if unless it considers the applicant has a sufficient interest in the matter to which the application relates. So what's a sufficient interest? As in it's relevant to you, not interest as in curiosity, but it's of benefit or possibly to your detriment if it goes the wrong way for you. So there was a case about this which set up the sufficient interest test, IRC and National Federation of Small and Employed and Small Businesses, Self-Employed Small Businesses, 1982. So the court has got some latitude in deciding whether you've got locus standi or not. So when you're seeking leave, the court has the power to turn down claimants who they feel are not substantially affected by the action they're seeking judicial review for. They don't want just nosy Parkers, troublemakers, launching loads of judicial review actions. So in most cases, deciding someone's got sufficient interest is an unproblematic issue. But sometimes it's trickier when that person isn't individually affected, but just feels that he or she is acting for the benefit of the public generally, like Miss Miller did with regard to Brexit. So courts, they are loath to say, no, you don't have locus standi if the case otherwise has a prima facie basis. Okay, so what is standing as per the Human Rights Act 1998? So the Human Rights Act has set up a different test. If you're a so-called victim of the act, assuming the act to be a bad thing, then you come under Article 34 of the European Convention on Human Rights. So the case law of the European Convention on Human Rights European Court of Human Rights has expanded the notion of locus standi. If your convention rights have allegedly been breached. So what's locus standi under common law? Well, at common law, there was a more limited view of locus standi to try and get rid of these really unnecessary, trifling claims, which were very feeble. So only a person who is really directly impacted by the action has locus standi, and this is called individual standing. Now, over the centuries, a wider definition of locus standi has developed. So anyway, if you think it's of constitutional importance, you'll probably be found to have locus standi if it really is an issue which has got an aspect of constitutionality to it, or indeed unconstitutionality. So you might have some sort of associational standing because you're a member of an organization which is involved in this particular activity that is impacted by the decision of the public body. So you can bring an action on public interest grounds. So individual standing, remember, is those who as an individual are impacted by the decision. For example, a prisoner, if he has been found guilty of some sort of disciplinary offence by a hearing in a prison, not in a proper trial, and punished and feels this is unfair. So this person blatantly has standing. There was a case about it, R and Hull Prison Board of Visitors, ex parte Saint-Germain number 2. That's a 1979 case. Or there was someone who was a Scientologist who was in the UK, I think, studying, a foreigner, I don't know which nationality, and the Home Office wanted to deport this person. Now, obviously, the decision to deport you as an individual definitely affects you, so yeah, you got locus standi. That's a no-brainer. Or there's another example. There was Schmidt and Secretary of State for Home Affairs. So in R and Secretary of State for Foreign and Commonwealth Affairs, ex parte Rees-Mogg in 1994, Lord Rees-Mogg, as the father of the current Honourable Jacob Rees-Mogg, he wanted judicial review, and before sincere concern for constitutional matters, it was to do the Maastricht Treaty, because the Foreign Secretary wanted it ratified anyway. So yes, he had locus standi. As it happened, Lord Rees-Mogg, he lost his case, so the Treaty of Maastricht stood. It was about integration, about setting up the European Union, transforming from the European Community to the EU. Right. So you can have representative standing, and this works in an associational basis. If there are groups and they're representing all their members who are affected, you could be like a trades union or professional association, something like that. So they have standing as a group. There was in a case about this, R and Liverpool Corporation ex parte Liverpool Taxi Fleet Operators Association, 1972. So the Liverpool City Council had duty to give licenses to taxi drivers, and to decide how many licenses it was going to issue. But the issuance of the licenses was contentious because the licensed taxi drivers didn't want too many licenses to be issued. Otherwise, there are too many taxi drivers, they don't get enough work. Anyway, so the city council said, oh, we won't issue any more for a certain period, but then had breached their promise without asking the Taxi Fleet Operators Association their opinion of this. So the association said, we want judicial review because they didn't go through the right procedure. Do we have locus standi? Anyway, the court said, yeah, the Taxi Fleet Operators Association does have locus standi because the taxi drivers are clearly affected by the decision to issue more taxi drivers' licenses. I don't actually know what the substantive outcome was. The point here is, did they have a locus standi? And they did. So there's another type of representative standing, and that's called public interest. So there are circumstances under which people say they're acting for the benefit of the public at large. An example of this was R and Secretary of State for the Environment ex parte Rose Theatre Trust, 1990. So a very narrow approach was taken to standing in that case, which is markedly different from cases such as Greenpeace or the World Development Movement, which I mentioned here and before. So in the Rose Theatre was the Rose Theatre Trust Company, and it was established to preserve the ruins of what was a theatre from Shakespeare's time on the south bank of the Thames in London. Because people were digging it up, going to rebuild something, and then they found the ruins of the theatre just by chance. So the group, they applied to the Secretary of State for an order under the Ancient Monuments and Archaeological Areas Act 1979, which would have given that area protected status. But the Secretary of State refused to do so, saying, "Don't be so ridiculous, we need to build over this." So the court held that the trust company that didn't have locus standi and therefore couldn't launch a judicial review challenge to the Secretary of State's decision. So the court said, none of you people have standing as an individual, and therefore you can't get standing just by banding together and setting up a trust. So there were similar decisions in other cases. For example, R on application of Plantagenet Alliance Limited and Secretary of State for Justice 2015. So that just tells you a little bit about judicial review. So this is what they have to go through to decide there's judicial review or not. Public body or de facto public body is exercising a public function. Okay, yes, the judicial review would be possible with this. Is it a public law issue? If yes, then judicial review could go ahead. If it's not a public law issue, no, private law. Is it justiciable? You need to say yes to that question as well for it to be for judicial review to go ahead. You need yes to all of these. So that anyone no, then it's no overall. So look at the procedural requirement. You seek leave from the court. You get it? Yes, you can go ahead. Have you applied within 3 months of the reason for seeking judicial review? Yes. Exceptionally, they might allow a longer time period than 3 months. Have you used all alternative remedies, if there are any? If the answer, yes, you have used them all. Okay, if there are any, that is, then okay, judicial review could be possible. Do you have locus standi, either as a representative or as an individual? If it's yes, then judicial review goes ahead. If there's no to any of that, no judicial review. So what can be the basis of review? So quite often we see the reasons for review. We look upon, say, Lord Diplock in that GCHQ case. Remember, Council of Civil Service Unions and Minister for the Civil Service in 1985 about a trades union in General Communications Headquarters, Britain's sort of spying place, as in for telecommunications, listening in. And this is what Lord Diplock had to say. Judicial review has, I think, developed to a state today where one can conveniently classify it into 3 heads on which administrative action is subject to control by judicial review. The first I would call illegality. The second, irrationality. and the third, procedural impropriety. That is to say that further developments on a case-by-case basis may not add further groups, with the possible adoption in future of the principle of proportionality. So illegality, in that GCHQ case, Lord Diplock said what illegality was. It is that the decision maker must understand correctly the law that regulates his decision-making power and must give effect to it. This is par excellence a justiciable question to be decided in the event of a dispute by those persons, the judges by whom the judicial power of the state is exercisable. So if there's illegality, the two types, ultra vires, which is going beyond your legal power, or the one that could be discretion, misusing your discretion, delegating it to another when you're not allowed to, or indeed fettering, limiting your discretion when you shouldn't have limited it, using your discretion for wrong reasons. So acting ultra vires, that's in Attorney General and Fulham Corporation 1921. The local authority had powers under statute, the Baths and Washhouses Act of 1846, but that didn't allow it to set up a commercial laundry. Or R and Richmond upon Thames Council ex parte McCarthy and Stone 1992, a local council set up a charge before applications if you were seeking advice on your planning application, and they weren't allowed to do so because it was not incidental to their planning powers. So let's think about exercise of discretion. This is the aspect of judgment that someone's going to use. It's not an absolutely clear decision, yes or no. The person making the decision has to use his or her nous. I might say yes, another reasonable person might say no, faced with exactly the same set of facts. So in administrative law, this is what K.C. Davis said about it. A public officer has discretion whenever effective limits on his power leave him free to make a choice between possible course of action or inaction. Okay, so most people realise that for government to actually work and to be a little bit flexible, there are circumstances which we cannot predict, and public bodies and officials, politicians, bureaucrats have to be able to use their judgment or their discretion. And there are many situations in which this can be exercised lawfully. But discretion has certain limitations. And the person who's got to make the decision has to actually make a decision, yes or no. They can't say nothing. And it must be used for the proper purpose, the purpose which was conferred. And usually you can't delegate it. If it's you who holds whatever position, chief executive or leader of the borough council or mayor, is you, the office holder, you've got to make it, and you can't give that power to somebody else. You can't pass the buck. You can get their advice, but the ultimate decision is yours. There's a Cartona principle, which is about government ministers being allowed to delegate certain decisions to civil servants. But okay, that's provided for in statute. Because the minister, he is the one at the end of the day who's answerable to Parliament and for the decisions within it, even if the minister didn't personally make that decision. He's got to carry the can. So anyway, these things, discretion cannot be so strict that it's a rule as such. It involves some latitude. Personality types affects this. Some people are more cautious, others more incautious. All right, procedural impropriety is also grounds for judicial review. If you didn't follow certain steps that you had to stop, and these might breach the principles of natural justice. Often a public consultation. They fail to do that properly, and there's judicial review. So there can be very simple situations. Agricultural Training Board and Aylesbury Mushrooms, a 1972 case. So because there was legitimate expectation was created and it wasn't fulfilled. One of the first civil cases I ever sat through was the legitimate expectation about closing fire stations and the level of fire cover. And did the local council have the right to close all these fire stations? And did people have a legitimate expectation they'd have so much cover from against fires from so many fire stations being open? Things like that. So let's think about what natural justice is. These are certain common law rules which were created by the courts down the centuries. And there are two very simple principles. No bias, can't be trying to help or harm someone or gain financially from it. And the right to a fair hearing, to have your day in court, to say your bit, to be legally represented and all the rest of it. So people might suggest, say, fairness. All right, there is one of the rule against bias. Remember, nemo iudex in causa sua. No one may be judges in his own cause. If you personally are involved, you own shares in this company, your sister's running that company, your cousin is whatever, a shareholder in the other company, or whatever, you stand to gain or lose from this decision, then you can't be involved, or someone very close to you is involved. How close is too close? That's a moot point. A first degree relative or spouse is definitely too close. So you can't be involved in that case. So there's actual bias, presumed bias, and apparent bias. Actual bias, well, this is what Lord Gough said in R and Gough 1993, is if a person is motivated by a desire to favour one side or disfavour the other. Okay, it could be for financial reasons, or because I hate whoever is an enemy of mine, or this person is a close friend of mine. That would be wrong. Now, presumed bias is when the person making a decision has a financial benefit to accrue to them from a certain decision, or perhaps a financial loss from a certain decision. Remember Lord Hoffman in that Pinochet case, because he was in an organisation that supported Amnesty International. This was a case of presumed bias, even though there wasn't a financial aspect to it. So Lord Brown Wilkinson, what he said is, if you've got any involvement with any organisation which is a party to the case, that's presumed bias. Lord Brown Wilkinson said, without any investigation into whether there was a likelihood of suspicion of bias. So Lord Hoffman, maybe he was going to act with complete probity despite his involvement in Amnesty International, but no, we're not even going to look into whether he really was biased. Just the mere appearance is enough for him to be removed. It would be deeply unseemly for him to be involved. There's apparent bias, and that is in a case where the decision maker is not instantly disqualified from the decision. There's a different test. This is in Porter and McGill 2002, a House of Lords case. If you find out all the circumstances which cause the bias and ask, in these circumstances, would a fair-minded and informed observer assume that there was a serious chance of bias? So everybody has the right to a fair hearing, aude alteram partem. I can't remember the Latin tag for even the devil has the right to a hearing. In McInnes and Onslow Fane, 1978, this was about someone seeking a boxing manager's license. Fairness is a concept which is flexible, and fair hearing, well, that depends on the situation and what effect the action decision would have. There are three different types of categories. There are forfeiture cases, and that's where some benefit or position is being taken away, and you require utmost fairness. There are also expectation cases, and that's where a person expects to gain some benefit or job or something like that. Then there are application cases, and that's where there's the lowest standard of fairness. An individual is simply an applicant. Now, something has changed recently. Lord Denning said in 1971, well, no, that's not recently, giving reasons is one of the fundamentals of good administration. So there's no common law duty to actually state your reasons, but the courts, they tend to attach some importance to this. There's also Wednesbury irrationality. So that is from Associated Provincial Picture Houses Limited and Wednesbury Corporation, 1947. Lord Green, who's a master of the rolls, he said this: if a decision on a competent matter is so unreasonable that no reasonable authority could ever have come to them, then the courts can interfere. Or GCHQ, Lord Diplock said, what can now be said succinctly referred to as Wednesbury unreasonableness applies to a decision that is so outrageous in the defiance of logic or accepted moral standards that no sensible person would apply to his mind to be decided could have arrived at it. Now, Wednesbury irrationality is very, very rare indeed. If it's totally irrational, then they can strike it down. So we have to. There are other areas where they really won't intervene even then. If it's to do with professional judgment, to do with financial matters, or really political matters, I can't think when they've ever done that. So there are other areas where the courts are more willing to find Wednesbury irrationality. There was Boudet K and Secretary of State for the Home Department 1987, and Lord Bridge, what he said there was, when an administrative decision under challenge is said to be one which may put the applicant's way of life at risk, the basis for decision must surely call for the most anxious scrutiny. So was it made on a reasonable ground or not? That's what the court will be looking at. So Wednesbury unreasonableness has been disapproved of by some. So Jowl and Lester in 1987, these two judges, and they published a book about it. They said proportionality is a better test because, Wednesbury is so unclear and so debatable. So proportionality, that's something that Lord Diplock said in that famous GCHQ case. He thought that might come as a ground for judicial review. So that's clearer than Wednesbury unreasonableness or irrationality. And UK courts are very at home with the idea of proportionality. It's in European Union law. European Court of Human Rights looked into it. So think about De Freitas and Permanent Secretary of the Ministry of Agriculture, Fisheries, Lands and Housing, a 1999 case before the Appellate Court. So Lord Clyde said there is a three-part test for proportionality. First of all, the aim of the legislation must be important enough to warrant limiting a fundamental right. Second of all, the measures intended to achieve this legislative aim must be reasonably connected thereto. And third of all, that the methods used to limit the right are no more than are needed in order to achieve that aim. So the House of Lords agreed in R. Daly and Secretary of State for the Home Department 2001. So the UK courts have two tracks this proportionality test. There can be Wednesbury irrationality, or there could be another part of the test. So irrationality, proportionality, they somewhat overlap. There was also a case, KU and Secretary of State for Foreign and Commonwealth Affairs 2015, which is also relevant to this. Okay, so that's just a little bit about judicial review. Toodaloo.